What we know is a drop. What we don't know is the ocean.
Hello, and welcome to the Newton Knowledge Podcast. My name is Mark Singer, partner of Newton One Advisors, and I'm joined by our managing partner, Steve Target. The Newton Knowledge Podcast will provide meaningful content to our valued advisor community. Our discussions will deliver unique insights into the people, processes, and products that make our industry so critical. Newton One is a national life insurance planning firm delivering customized solutions structured to help clients and their advisors engaged in solving estate planning, wealth transfer, business succession, and executive benefits challenges. We are a member of the M Financial Group, which grants our clients access to the nation's elite carriers and exclusive products available only through our network.
I was telling Scott Radcliffe we were talking about doing another. Mark and I have done some work with ESOPs, and we did a ESOP-related podcast out in Lancaster.
Okay.
And it was the only one where something happened, right? The recording, the mics weren't hooked up, or something went awry.
Oh man.
And we had to pick up all the sound from the camera.
It didn't sound well.
Which was bad.
Oh, no.
But it worked. We did a recording at the Union League.
Okay.
And it was our first live recording. You remember that? In front of the business forum. So there was 20, 30 people there.
Yeah.
And they had their own setup team that kind of helped us.
Yep.
Nice.
We did it wrong. It didn't. So we're at the end of it, and I click to save the project, and it says, "Do you want to start recording?" And I'm like, so I look at Steve. I'm like, I don't think we recorded a thing here.
Oh.
And everyone was like, send the podcast and all. They were able to pick it up through other microphones or something. Thank God. So it worked out. But it was like,
to redo it.
no, I was like, we just sat up here and talked about how we know how to.
There was more
record.
people. There was probably 75 or 100 people there.
Yeah, it was a lot of people, and I'm like, we just botched this whole thing. We're talking about we're the podcast people, and we ruined it. But it worked out.
You know what? And like, that is life.
It's just you just roll
like,
with it. Yep.
And
Like,
there's nothing to do but
just keep going.
keep going.
Keep going.
I hear that.
Okay, are we ready?
Sure.
Let's do it.
And so I assume these are directed to me, right, Mark?
Everything's directed.
Okay,
to
all
you.
right. Just
Yep.
I was like, I'm
You're the only one
we're
we're the only one we're talking to.
opining about it.
Today we have a dear friend of mine. I think Jenny, we've known each other for almost 5 years now.
Yeah, 4 or 5 years.
We both have had the opportunity to serve on the board of the Delaware Estate Planning Council. Jenny's a lot more important than myself. She was the immediate past president?
Yeah, I'm in the best spot on the
Yes,
board, which is
good for
immediate
you.
past president. It's my final year.
Beautiful, and you did a great job. Jenny is a partner of McCollom, D'Amelio, Smith, and Uebler, and her focus is estate planning. And today we want to talk about one of your briefings that you provided us in terms of protecting assets within trusts, particularly focused on divorce. So to kick it off, let's just start with a very simple explanation of what an irrevocable trust is and how it can be used to protect assets amongst divorced.
So an irrevocable trust is a trust created by someone. It could be created during their lifetime or not come into existence until after they pass. But with an irrevocable trust, it's a gift to a trust, and who the beneficiaries of that trust may be can be flexible group there. Usually it's created for family, but we'll be talking about a couple different permutations there. And I think usually when we're creating an irrevocable trust, it would be what's called a completed gift, meaning you are making a gift to this trust and you can't take it back. If you can, then we've got some other problems and it's probably not going to work. But kind of on the most basic level, that's what we're thinking about in the context of an irrevocable trust. And one of the most kind of salient reasons to create an irrevocable trust is, looking down the line and being concerned about making sure that those assets that you're giving to your loved ones would be protected in the event of divorce.
Can you give some examples of protecting those assets within a trust, and what are those advantages and how those protections actually work?
So oftentimes, we own our assets as we do, and if you're married, many times those might be owned jointly. Joint assets, no protection, right? No protection for those. And even your separate assets, perhaps you and your spouse came into the marriage with separate assets. Maybe you got married later in life, right? If you get married in your 20s, oftentimes you don't you don't have any money at all, and so maybe it's a non-issue. But if you came into the marriage perhaps with inherited assets or got married later in life, had the opportunity to earn some, set something aside. Oftentimes, in the context of divorce, those assets could nonetheless be subject to claims by the divorcing spouse for some kind of marital distribution, right? So, and that distribution is not always 50-50. I think sometimes there's often that presumption that it might be 50-50. I'll tell you, I'm working on an estate right now where we actually represent a person who had gotten divorced, but they had not completed the separation of the different marital assets. So now that had to happen post-death. And in that context, it's a 70-30 split, 70% to the person who is the former spouse, and the estate is only 30%. So in the context of divorce, there is shedding of assets as it is divided between the spouses. But using an irrevocable trust, in particular, a third-party irrevocable trust, meaning, for example, the most classic situation is I create a trust for the benefit of my children. And when I pass away, different trusts will be created for each child. In those contexts, there is very strong case law, I would say, nationwide, in particular here in Delaware, but nationwide, you have strong protection that those assets that you set aside for your child as their inheritance, if you put it into a trust, very, very good protection from your former son-in-law or daughter-in-law when they divorce, walking away with half or maybe even more of their inheritance.
Can you touch a little bit on this? I know we didn't plan this, but in terms of the state of Delaware, just to give you and your team a shout out since you're down here, you said if trusts are structured here in the state, what are some of the advantages on a high level? I know you could get very detailed in this matter, but just for the audience.
Yeah, Delaware has strong statutory law as well as case law supporting what are called spendthrift provision. A spendthrift provision is what protects the trust from the claims of your creditors. And unfortunately, the most significant creditor in most Americans' lives would be that of a divorcing spouse. But there are obviously other creditors out there too. Say you're in a car accident and God forbid somebody gets $1 million judgment against you. The assets in a trust with that spendthrift provision are protected from the claims of your creditors. So they might be able to go after and, attach your wages, or you've got a vacation home and they can, put a lien against that. But the assets in an irrevocable trust with this spendthrift provision, the creditors can't come after it. Now, you get a distribution from that trust and you put it in your bank account, well, all bets are off. But while the money's in that trust, it's protected. So it's really powerful, I think, for the vast majority of our clients, they want to ensure that the money that they're working so hard to create, when they pass it to their children, they want to make sure that it's going to benefit their children and grandchildren. They don't want half of it disappearing with a divorcing spouse.
That could be like the most important aspect of it.
Yeah, I think in so many of my meetings, I talk about, well, how should we structure these trusts when you pass for your family? And, oftentimes, and obviously, if you have young children, you got to have, you can't be leaving assets outright to a minor. That makes no sense. But also, even when I have, and then if you have a child maybe with special needs, you got to create a trust. Or maybe you have a child with addiction issues, and giving them the money outright would be really a bad idea. But, so there are all kinds of factors like that make sense for trust. But even if you have kids that are just, all-stars, they're great with money, they're established in their careers, all these other factors, they're doing everything right, but still, you just never know what might happen in the marriage. You never know. And it might not be, right? It might not be 5 years in or 10 years in or even 20 years in. And I think because, people in their experience have seen this, they know that it makes sense to add that other layer of protection for their children by giving them their inheritance within a trust as opposed to outright.
So we're a life insurance advisory firm. Mm-hmm. Can you tell us the advantages and flexibilities of owning a life insurance policy within a trust for proper estate planning needs?
So with life insurance, absolutely, you can create what's called an ILIT, an irrevocable life insurance trust, and that can be a great strategy for the ideal candidate is someone who, well, we might be worried about paying an estate tax, so they might have a substantial estate. Currently, it's just under $14 million per person is the federal estate tax exemption. We don't exactly know where that's going later this year.
Can you tell us?
If I could, let me tell you, I sure wish I could. But when we have with an ILET, it makes perfect sense for clients who maybe have their wealth is locked up in real estate or in a closely held business or something where we don't want to have a forced liquidation, right? We don't want a fire sale after someone dies to create the necessary cash to pay that estate tax. So with an ILET, an irrevocable life insurance trust, you create the ILET and the policy is owned by the trust from the jump. And that means that it's not subject to the estate tax when you die. So basically you're creating a mechanism to provide liquidity so that your heirs, your beneficiaries can inherit what you want to really give them and not be forced to sell it off in order to pay any taxes.
Let's Jenny, let's have some fun and come up with some case studies.
Okay.
So the first case study is focused on a divorce proceeding for a client and how an existing trust may be looked at. So let's assume the trust was created by Mark in 2005, and he created a trust for the benefit of his wife and the children. The trust defines spouse as the person that Mark was married to and residing with at the time of a distribution, but in 2024, Mark initiated an action for divorce. His wife brought a motion to declare the assets of the trust marital property subject to equitable distribution. How do you think the court would rule on his wife's motion?
So I'd like to tell you that no issues, no problems here, but that's not necessarily going to be the case. And in large part, this is going to be really facts and circumstances driven, and it's also going to depend what jurisdiction you're in. So what Steve, you just described is an example of a SLAT, a spousal lifetime access trust. So it was a trust Mark created for the benefit of his spouse and children. And it also contains something that's a little specialized or nuanced. You don't see in every trust agreement, but that's called a floating spouse definition, which means that you define your spouse as the person to whom you are married at that time. So that can be, and obviously, as you well may imagine, in the context of divorce, that can be very problematic because nobody wants to be replaced by someone else as a beneficiary in a trust. So we've had some different kind of interpretations of how those trusts are being treated, and it's going to be really, really, I think, dependent on the facts of that particular divorce proceeding and where you end up in court. So where you create the trust is important in terms of what outcome you might achieve. But just to run through a couple different cases that we've seen that have had kind of similar facts to what you just described, there's Nelson versus Nelson out of Florida. And that was just from a few years back, 2016. In that instance, prior to the divorce, they transferred a house to the trust, and the court found that by virtue of doing that, it placed it outside of the divorce court's reach for purposes of equitable distribution. So I think that was what we would say a positive outcome, what we would want to see, consistent with what we would anticipate in the context of you create a trust and comply with all the appropriate formalities. We'd want to see that that's not a marital asset anymore once you make a completed gift to that trust. Another case is Murphy v. Rossow, and that's actually out of North Dakota, 2010 case. And as North Dakota trusts often contain, this one involved mineral rights. And in this instance, subsequent to the divorce, a few years after the divorce actually concluded, there was a claim by former spouse to benefits that were only distributed from the trust 4 years later. So after the whole divorce proceeding had completed, but there was an attempt to kind of go back and get more when the trust terminated and assets were distributed outright. And in this instance, the court did find, well, at the time of the divorce, though, that the mineral rights, they were owned by the trust, and it was not a marital asset. So they said no, that subsequent termination in accordance with the terms of the trust agreement was not then a new event that would lead to a marital distribution of those assets. So I think, another, what we would say, a win from an estate planning standpoint. Then we had one other case out of New York, and that's Traffilet v. Traffilet. And this one was a bit more questionable, I would say. Here, the parties, they created and funded an irrevocable trust with husband's interest in a business entity. And the court concluded that was marital property at the time the trust was funded. The trust agreement contained several provisions, including the power of the protector to terminate the trust and distribute property to settler's wife, and similar to that floating spouse provision we just talked about. And here the court concluded that under these circumstances, whether the trust should be subject to the wife's equitable distribution claim was a genuine issue of material fact that could not be decided on summary judgment. So, and then ultimately they settled out. So we don't know how ultimately the court ruled on this issue, but here this was there was not just an outright determination that you put it in the trust, it's not marital asset. So again, facts and circumstances are going to be important. The jurisdiction that it's being litigated in is going to have an impact on what assets ended up being considered as part of the marital distribution.
Interesting, thank you. All right, so let's take another case study, and we're going to look at Philippe, who created a trust for the benefit of his daughter, Darlene, and funded it with a vacation home used throughout the administration of the trust by Darlene and her husband. Darlene had the power to remove any trustee and replace any removed trustee with any trustee not considered related or subordinate to her based on the definition of the tax law. So subsequently, Darlene commenced an action for divorce. Her husband, Philippe, brought a motion to declare the vacation home marital property subject to equitable distribution. So how do you think a court would rule on this motion?
Well, gosh, so this is a third-party dynasty trust, right? This is dad created a trust for the benefit of his daughter. He transferred this gorgeous vacation home to the trust, and then, years pass by, and daughter's husband, they divorce, and that husband now says, hey, that vacation home that my former father-in-law put into this trust, that's mine, or I have a claim to it. So, as a parent, I would say, holy smokes, that's
right.
That's remarkable.
Right? Yeah,
it's remarkable.
You got,
but it happens.
It totally happens.
Yeah.
So that was the claim that was made, that this divorcing husband is saying, hey, I have an interest in that vacation home. We live there together as a family. He even said that he contributed assets to the upkeep and of the property that increased its value. So he made a claim that, well, he should have, if not as to the full value of the property, basically the increase in its value during the course of the marriage, right? He was going at it from all these different angles. And so ultimately the court here said, no, those contributions we made, that was not of such significant value that we're gonna give you any credit for that. But what the court did say is that this is wife's separate property. That's not actually ideal, because what I would expect to hear and want to hear is that is the trust property, right? Wife, that's not your separate property. And that to me, and when the kind of drawback there is, if it's your separate property, the court may take that into consideration when divvying up other assets, right? So it's like, well, if you have this separate property here that provides for you, maybe you need less of this marital property. So when determining other kind of aspects of the division of property, it comes into play. And so, it's a little bit of a head scratcher. Why did the court make that determination? And I think there were two facts here that might have influenced it to make that determination. One was the fact that when dad purchased the property, at the time, the original deed to the property was in dad's name and daughter's name. I don't know why, because dad contributed 100% of the value to purchase it. But the original deed to that property showed it as the two of them as the owners.
Oh, so the daughter was on the deed.
Correct.
Interesting.
And then subsequently there was a new deed whereby it was transferred to the trust. Mm-hmm. But still, I think that was a bad fact here.
Yeah.
And then the other thing was that the court seemed to focus on was that there was the role of this trust protector who could terminate the trust. And I think, and even though daughter herself couldn't serve in that role and she had to choose someone who wasn't related or subordinate to serve in that role, I think the court felt like, well, that's you having some level of control over this trust that, caused concern on some level and made it seem like perhaps this should be, that the house at least should be treated as her separate property as opposed to considered marital assets. So I would say that trust, again, this is the Rikers Trust out of New York. Ultimately, son-in-law didn't get that vacation property, but the outcome wasn't a home run.
So I don't like this next question because no one anticipates a divorce, I would hope. But what steps can an individual take to protect their assets through trust for the possibility of a divorce? What advice would you give?
So your options are obviously far more limited if you are currently married. If any of us had that kind of hindsight and we would do things differently. So there's absolutely the ability to create a trust. In Delaware, for example, you can create an asset protection trust prior to your marriage. And that is a very effective way that's often used by clients where you have a situation where one person is not interested in a prenup. You can, prior to the marriage, create a self-settled asset protection trust to protect your separate assets. Now, once you're married, whole different situation. Can't do that. Can't do that absent a valid and binding postnuptial agreement, the knowledge and participation by the other spouse.
And the knowledge is important to that,
Oh,
right?
for sure. Yeah, disclosure is what's critical, and that they fully understand. I mean, there can be situations where a spouse might waive his or her rights, but you got to have a complete disclosure to make that valid. But I would say absolutely in the context of your clients who are creating trusts for their children, that is where I think we have a really high level of comfort to say you can create this trust for your children and ensure that their inheritance is protected and will be used by them and your grandchildren and great-grandchildren and not a divorcing spouse. I think that is truly, and I've had situations where clients will come in and will start with a certain type of trust that might terminate and go outright at certain ages. And we end up later on down the road, we change and create a lifetime trust for their children to ensure that it will be protected in the event of divorce or other things that we can't control, like other creditors out there.
Super helpful. So a little more on the lighthearted side. If you've been chosen to represent your country in a global competition, what sport or activity are you doing, Jenny?
Well, it would have to be Pilates. If there was the Olympics for people age 40 and up in Olympic Pilates, sign me up. Or if I couldn't make the team, I would go to cheer on the other people.
Steve loves Pilates.
Oh yeah, that's awesome.
Yeah, congratulations.
Jenny, this was good. It's always great connecting with you, and I always take something away when you have a chance to discuss what you do. So
that's
we really
kind
appreciate
of you. I really appreciate being here today and speaking with both of you. Thank you so much.
Bye. Goodbye.
The material and opinions voiced are for general information only and are not intended to provide specific advice or recommendations for any individual. To determine what is appropriate for you, please contact a member of our team.